Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis. Today we are jumping into the state's response, finally, on the Murdaugh's motion for a new trial based on the allegations that Becky Hill tampered with the jury. So as you'll recall, what happened was setting the stage for this was we had the appeal and then we had the motion that Murdaugh's team filed to stay the appeal, send it back to the trial court level, let them file a motion for a new trial. They filed that motion for a new trial, then they immediately filed a petition for a writ of prohibition to not allow Judge Newman, to disqualify Judge Newman from hearing anything more about this case. And now we get the response that the state, on behalf of Becky Hill, is responding to this motion. And let me tell you, it is a doozy. There's some really great stuff in here, really entertaining stuff, actually. It's 25 pages. We're going to, like we always do, get to the main points, give you what you need to know, do all the hard work for you. And there's also a lot of statements that they attached. Also, so in total, it's about a 45-page document. You can go ahead and download it and read it all you want, but I am going to just cut it all, explain it all, analyze it all, and let me tell you if whether they have some good arguments to make or not. So here's where they start. Okay, let's start with the premise for the motion for a new trial, right? So remember, the premise for the motion for a new trial by Murdaugh's team was the fact that Becky Hill tampered with the jury. And by the way, I didn't say this yet, but please, if you haven't yet, subscribe, like the channel so we can continue growing. Okay, so Becky Hill, the allegation is that she tampered with the jury, and by making certain comments to them, like watch his body language and don't listen to what he says, or things like that, right? So one of the quotes from the cases that the Murdaugh team brought in their motion, which they feel is a very strong basis for a new trial because of the comments that Becky Hill made, was that anytime a court official makes any comment about the case, that should essentially automatically require a new trial. If any court official says to the jury something about the case, something about a witness not being credible, or a comment about the evidence, their position is that that should automatically require a new trial. The first thing that the prosecution does is say that that's incorrect. That's incorrect, and they bring cases which show it's not just the fact that somebody made a comment about the case. And this is what they quote. Not every inappropriate comment by a member of court staff to a juror rises to the level of constitutional error. So it's not a constitutional error just because they made an inappropriate comment. And then they continue and they say, they bring some cases, and the cases they say like this: holding that not all communications with jurors warrant a hearing. So not all communications that somebody made warrants a hearing. And that the defendant must show that that unauthorized contact created actual juror bias. So you have to not only prove that an inappropriate comment was made, but that actually created a bias in the juror. So if an inappropriate comment was made, but that didn't really do anything, and the juror will testify, yeah, I shrugged it right off. I didn't really play any role in my deliberations and my thought process, then you're out of luck. So that's the first important law, first important rule that the state wants to respond to, is that it's not just, let's just correct it right away. It's not just any comment that they make. It has to be a comment that actually created a bias by the juror. It actually moved the juror. It actually affected the way that the juror perceived the case and deliberated in the case. So they continue and they say that if they do show, even if they do show that there's been a comments that were made that actually require an evidentiary hearing, they say like this: if that prima facie showing is made, the resultant evidentiary hearing is a strictly limited, judicially conducted affair, particularly as concerns examination of the jurors. So they say, let's get your cross-examination gloves off. Tell the Murdaugh team, you're not going to be able to cross-examine these jurors. Only the judge is going to be able voir dire, to question the jurors about what happened and the contact that happened. It's not just open game for the defense attorneys to question them. And they cite a case here, which a very similar situation happened. And the judge asked the following questions to the jurors. Number one, was your verdict guilty on both charges, and is that still your verdict? That was the first question he asked the jurors. And this is, again, very similar situation where there was alleged jury tampering. Number two, was your verdict based 100% on the testimony, evidence, and law presented at this trial? That was the second question. Number three, was your verdict influenced in any manner by any communications with any of the bailiffs or any other person outside of the 12-member jury? So was it influenced by any of the bailiff or any other person outside of the 12-member jury? That's an important question also. And finally, did you have any communication with any of the bailiffs or with a third party not part of the jury? And if so, please relate to the court what those communications were. So that's what happened in this case, the case that they're quoting, which is a State versus Green case, where that happened. The judge called each juror individually to the courtroom, asked them these 4 questions, and that's it. And then on appeal, the court on appeal said that they commended the trial court's deft handling in that situation. So they basically, the Supreme Court and the Court of Appeals both agreed that this is the way you're supposed to conduct any type of evidentiary hearing. So even if the Murdaugh team can convince this court that an evidentiary hearing is warranted, it should be done in the following process, that only the judge should be able to ask questions. And here's what they say. But for proposed questions submitted and subject to judicial pre-approval, meaning the attorneys could submit other questions. You're not limited to those 4 questions per se. Let's just say if the attorneys want to send other questions, submit other questions to the judge for pre-approval, that those questions could be asked by the judge to the juror, that's okay. The court should not permit interrogation of the jurors by the parties or their attorneys. Why? And why is that? Well, they lay it out very nicely in their brief. Jurors are citizens who have committed a tremendous service to their community and country through the sacrifice of time and effort to weigh on the most serious issue that can be put to them, a man's guilt and his freedom. So they did a very important job. The jurors all did an unbelievable service to the community and the country. And they decided a man's guilt or freedom. Jury duty is a cornerstone of civic duty, and needless exposure of jurors to litigative stress and impeachment by zealous attorneys, particularly in a case of this with this level public exposure, can only serve to further discourage citizens from willingly participating in this duty. So they're saying, look at this. What's going to happen here? You let Murdaugh's defense team go and cross-examine these poor jurors. What type of incentive is that going to be for any future jurors? Anyone's going to be sitting on a case, they're not going to want to be sitting on the case. Why? Because number one, it wastes all your time. And you're spending a lot of time on this case. You're deciding someone's fate. And then afterwards, you're going to be dragged back into court and be cross-examined by the losing side. Who wants to do that? So the prosecution is saying, the state here is saying that there's a very strong reason why the judge should be the one conducting the voir dire, the questioning of, number one, the jurors, and guess who else? Becky Hill. They don't want Becky Hill to be the subject of the cross-examination by the Murdaugh team. They're going to have a field day with her. They're going to try to crush her and make her look like a liar. So therefore, the prosecution, the state is saying, look, we just brought you this case, which was commended by the Court of Appeals and the Supreme Court, that the way that this should go, if there is an evidentiary hearing, which they're not agreeing to, if there is an evidentiary hearing, the process should be that the judge asks the questions. The attorneys can submit questions, but the judge is the one to ask the questions. Finished. So that's their first argument. Then they continue and they make an argument to follow. They have, remember, we have an affidavit by one of the jurors who actually deliberated. One of the jurors who actually deliberated made allegations that Becky Hill said certain things like watch him closely, watch his expressions, watch his body language, things like that. the prosecution, the state here argues that juror 630 just simply made a mistake. She didn't realize, or he didn't realize, this juror, that Mrs. Becky Hill never said these statements. In fact, they pulled up the transcript from the opening statements and the closing arguments by the state, by the prosecutors, and they say, look, the prosecutors were the ones who said those statements. It wasn't Becky Hill. This juror just made a mistake. She thought it was Becky Hill. Really, it was the prosecutors in this case. And they pull up the transcript, and this is what the transcript says. I'm not going to read the whole transcript, but look, this is what it says. Watch those closely. Watch his expression. Listen to what he's saying. Listen to what he's not saying. So don't let him fool you too. They said that in closing arguments. Body language is so important in life. So they're simply, the state is saying that this juror just simply made a mistake. She made a mistake. She didn't realize that really this was the prosecutor, and she knows that she heard these statements somewhere, but she made a mistake. She thought it was Becky Hill, and really it was the prosecutor. That's a nice argument to be made. Now again, is it going to get over the fact that she actually put in an affidavit, her sworn testimony, that it was not the prosecutor, it was actually Becky Hill? Was that really just a sleight of hand by the Murdaugh team convinced the juror that it was Becky Hill and not the prosecutor who said it? It's possible, but she did put that in an affidavit and she signed it. But this is an argument that the prosecutor in the state is making against that juror, that even though you have this one juror's affidavit, that's not going to help you. Now, then they talk about the egg lady juror. Now remember, the egg lady juror is the famous juror, juror number 785. And she was dismissed, and part of the reasons why she was dismissed, according to the Murdaugh team, was because this whole Facebook post by her alleged ex-husband, some sort of Facebook post, really, that has nothing to do with it. It has to do, this is what the state's argument, it has nothing to do with that Facebook post. That's not why juror number 785, the egg lady, was dismissed. That has nothing to do with it. It had to do with an email that was received regarding this juror talking about the case with some other people. Nothing to do with the Facebook post. It has to do with her discussing the case with some tenants, and they go through the whole process about how that happened, what exactly happened. The court interviewed them, and it talks about also how the court brought up the Facebook post also, but specifically, the judge said, just find it, the court emphasized its ruling had nothing to do with anything brought up about the juror's ex-spouse. It had nothing to do with that, nothing to do with this Facebook post. And in fact, later on, they say, unbelievable. They say, why is it that you think that Murdaugh's team is making such a big deal about this Facebook post? Why do you think they're doing that? So first, they lay out in their response, how is this? Let's try to think how this is really supposed to happen. Okay, let's think about what their argument is. Let's put this all in context. And this is what they say. Indeed, the machinations alleged do not even begin to make sense. Under Murdaugh's theory, Clerk Hill heard the court had received an email which implicated a specific juror, then, in immediate response on the fly, reported a fictitious Facebook post to implicate that same juror, then conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by somebody with the same name as the juror's spouse, which she then reported to the court in an effort to get an uncertain juror removed so as to ensure some outcome that would support a book deal she did not at the time have. So they're saying, what's this idea? The idea is that as soon as she heard the email, she right away told the judge about a made-up Facebook post, and then quickly and luckily got another staffer to another court staff to go and conspire with her and quickly look through Facebook and try to find an apologetic post. I mean, it's just so far-fetched that's what was going on. And then they say, only Alex Murdaugh can conceive of such a confounded gambit as even remotely plausible. And he is projecting his own calculating, manipulative psyche onto a dedicated public servant in an effort to save himself. So they're saying this could only be the crazy thinking of Alex Murdaugh, and he's trying to make it look like this public servant, this dedicated public servant like Miss Hill is doing such crazy ideas. And then they say, this is the real reason. This is the argument that they make. This is the real reason why they're talking about the Facebook. This is what they say. Strategically, Murdaugh's inclusion of the Facebook post narrative appears to be a desperate effort by Murdaugh to preemptively impeach Clerk Hill, to bring into dispute irrelevant facts, in order to support his petition for a writ of prohibition. Remember, we spoke about the petition for a writ of prohibition. They don't want, the Murdaugh team does not want Judge Newman presiding over the evidentiary hearing, over the motion for a new trial, over the potential new trial. They don't want Judge Newman near this case anymore. They feel that he's against them. Now, how are you going to support your petition for a writ of prohibition, which, remember, they filed with the Supreme Court, to have the Supreme Court order that Judge Newman is not allowed to preside over any of these hearings? And the only way that they can do that is by showing that Judge Newman had some personal knowledge about what happened with his clerk, Becky Hill, and that he had conversations. Well, which conversations did he have with her? The only conversations that he had with her that nobody knew about were the conversations about the Facebook post. So therefore, the state is arguing that the reason why Murdaugh's team is injecting this whole theory about the Facebook post, when very clearly it had nothing to do with the fact that Juror 785, the Egley, was dismissed, the reason why they're injecting that is just to support their petition for a writ of prohibition, to support essentially their motion asking the Supreme Court to disqualify Judge Newman from hearing this. And that's the only reason why they're doing it. And they have another reason. Ready for this? This is the second reason. And to beef up what would otherwise be a thin, blandly legal filing, not likely to draw attention to the various media efforts of his legal team. Meaning that they want this to be all over the media. The Murdaugh team wants this to be all over the media. That's why they had this press conference. That's why they want this to be all over the media. And it's much more juicy when you bring in the Facebook post and that whole situation that Becky Hill made it all up. It's much more appetizing to the media, and that's why they're bringing all this stuff up. So two reasons. Number one, because they want to get Judge Newman disqualified, and number two is because, otherwise it's a thin, bland legal filing. Now, that I got to give them points for this because I appreciate it. I enjoy snarkiness. I enjoyed the sharpness. I enjoyed it all. But let's be real here, okay? The media would be all over this regardless if there's a Facebook post or not. You got an affidavit from a juror saying that Becky Hill tampered with her and told her, don't watch his body language. Of course, yeah, it does beef it up a little bit, but let's not call it thin and bland. It's not thin and bland. I mean, this is crazy stuff what's going on. These allegations are crazy with or without the Facebook post. So the media is going to be having a field day with this regardless. Okay, but that's another argument that they make, which again, I appreciate it, I enjoy it. But at the end of the day, I don't know, how strong an argument that is. But they do make a very good argument showing that this really had nothing to do, the reason why that juror was dismissed had nothing to do with the Facebook post and only had everything to do with the email that they received about this juror speaking with other people about the case. Okay, that is a very good, fair point. Now, they move on to another part of their response. So really the first part of their filing is a response to the motion. Another, what they also call this is a motion to strike. And one of the things that they're asking to strike is the affidavits by the paralegal, right? So what happened here was that there was this one juror who actually agreed to sign an affidavit. That was juror 630 or something. I may have mixed up the number, but that was actually one juror. And now there's also the paralegal, if you remember, submitted an affidavit that she spoke to jurors, some other jurors, and those other jurors told her similar information, and then she put it in an affidavit, and they filed that with their motion for a new trial. So the state now is moving to strike that affidavit. Why? Because it's inadmissible hearsay. Right, here they go. In support of his motion, Murdaugh provides two affidavits from counsel Harper-Tullian's paralegal, Holly Miller, which largely purport to reflect statements made to or otherwise in her presence by two jurors, jurors 741 and juror 326. And they say this is textbook hearsay. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted, right? So this is textbook hearsay. The paralegal is saying to the court, what the juror told her, right? That's hearsay. She is saying over what the juror told her. That's textbook hearsay. So therefore, they're saying that it should be stricken. And then they say, an affidavit from Miller is not tantamount to an affidavit from the juror themselves, and constitutes textbook hearsay. Accordingly, the state moves to strike in part as inadmissible hearsay, okay, those parts of her affidavit. Now, what do I think about that argument? What I think about that argument is that it's not the greatest argument. Now, why? It seems that they're 100% correct. It's hearsay. Well, you know what else is hearsay? This may come as a surprise to you. But you know what else is hearsay? Affidavits themselves. Even if you have an affidavit submitted by a person saying what their own personal knowledge is, and they do it on their oath, and they have a notary public sign it, they have everything to do the affidavit 100% perfect, that is textbook hearsay also. It's an out-of-court statement, and it's being offered for the matter, it's truth of the matter asserted. It is textbook hearsay also. So then who cares? So then wait a second. If all affidavits are hearsay, so then what's the point of affidavits in the first place? It's all hearsay anyway. And the answer is that you have to understand the process a little bit about how this all works, okay? Not every filing you need to attach what would be considered admissible evidence, okay? When you need to get an issue in front of the court, you don't always have to submit what would be admissible evidence. You can show the court enough of a reason that the court should have a hearing about something. That you're allowed to do. And that's acceptable practice. So if you're filing a motion, you're filing something that you want the court to do, you attach affidavits. Oh, affidavits are hearsay, they shouldn't. Even though they're hearsay, but you're letting the court know, look, this is an important issue, and we need to bring it up in front of you. Perhaps we need an evidentiary hearing. And the reason for that is that we have these affidavits that people did sign under oath. They are affidavits. They are said under oath, even though they're not technically admissible. But there's a compelling reason why we need to have an evidentiary hearing. And then sure, bring those people into court, and we'll use 100% the rules of evidence. But it's just really to get us into the arena. It's just to get us into the courtroom to have an evidentiary hearing. So then you're allowed to attach affidavits. And not only that, but the prosecution, the state, attaches as support to its response, and its response to the motion for a new trial, it attaches all of these statements given by the jurors, by other jurors, and statements given by staff of the court. And these are statements. These aren't even affidavits. These are just voluntary statements that they wrote out. Well, that's for sure hearsay. That's for sure not admissible evidence. And they're attaching it to their motion. So how can they have a double standard here? So the answer is that they're arguing it. I mean, it's a good argument. I mean, they can make the argument. But for our purposes, the purpose that the Murdaugh team is trying to get here is just that we should get an evidentiary hearing. That it's not going to really talk to that part, because it's just to get us into the door, to show that this is an important issue that needs an evidentiary hearing. So the same way that those affidavits can come in, so too the statements come in. And just to play the card anyway, let's just play the card. You could argue, the arbitration team could argue, and again, I'm not suggesting that this is a good argument or not, but I'm just pulling it out of my head as I'm speaking now. So like I said, first of all, it doesn't have to be admissible evidence. Number two is that you could argue that the paralegal is allowed to testify about their state of mind, right? Remember, hearsay is going into an evidence class, but hearsay is only not admissible if it's being offered for the truth of the matter asserted, which means that they're saying Becky Hill said A, B, C, and D. So you're not allowed to offer it as evidence that Becky Hill actually said those things, but you could offer it as what the juror's state of minds were. What were the juror's states of mind? Well, their state of minds were that Becky Hill said these things to me, and therefore their state of minds could have been altered because of certain actions that Becky Hill took. Okay, so that could be an argument, even if we would accept that everything that you attach to a motion has to be admissible evidence, which is never the standard. Okay, so it's a cute argument. Yeah, it is hearsay. It's maybe it's a double hearsay really at this point, but it's not going to make so much of a difference in terms of really whether the court should entertain these affidavits and the information in them to see whether they should grant an evidentiary hearing. Okay, let's move on. Now they also make a mention that we have to remember. This is something that the state argues, that we have to remember that the thought process about how the jurors came to the conclusion, that's out of bounds. We're not allowed to really ask the jury, why did you decide that he was guilty? Which evidence did you like? Which evidence didn't you like? You are allowed to ask, what did Becky Hill tell you? Did she tell you anything? Number one, did she tell you anything? Number two, what did she tell you? And number three, if she told you something and you tell us what it is, did that have any influence on your decision? That's it. You don't have to start getting into, well, what other evidence did you feel was important in this case? That, of course, that's out of bounds. You're not allowed to ask those questions. So that's another point that they're making, that it has to be very limited exactly in what you're allowed to ask. And also another point that they bring up is that the fact that if a juror feels pressured by other jurors to come to a conclusion, that's not good enough. That's not good enough to warrant an evidentiary hearing. If a juror agrees that they were just pressured to come to a guilty verdict by the other jurors that were in the room, that's not good enough. And there's a case law about that says just because they felt pressured in the jury room, that's not good enough to overturn the verdict. Now, something interesting is that, like I said, they did attach a lot of these statements. They did attach a lot of these statements by other jurors. What's interesting is that they admit in their response that some of these other jurors did agree that they heard remarks by Becky Hill about the evidence. For example, there's two jurors who said, pay attention, that they heard Becky Hill tell them, pay attention, look at body language and be observant. So there were some statements, even in their statements, of these jurors that are coming on the side that they weren't influenced or anything. They did hear certain statements, and some of them said that they did see other conversations between Becky Hill and other jurors, but they didn't always hear those conversations. So they did say certain things like that. Now, if the conversations were just limited to what type of water do you like, then that's fine. But the fact that Becky Hill was saying anything to them about the case, that's improper. Now, whether that warrants a new trial is another question. But certainly, nothing should ever be said about the case between the clerk and the jurors. And even some of the jurors on their side, on the state side, said that certain comments were made. So that's just an interesting point that they put out here. Now, another argument that they make, and they're really attacking juror, the egg lady juror 785, another argument that they make is that juror specifically was asked in a hearing if Becky Hill discussed the case with her. She was asked this in her hearing before she was dismissed. And she said, not that I am aware of. And that's in the transcript. She said that. And then they argue. It's strange. It's hard to believe that juror 785 would not be aware of Clerk Hill's supposed statements when specifically asked by the court at a time proximate to when they were allegedly made, but would suddenly recall them many months later after learning Clerk Hill published the book. Why would this juror 785, at the time when they asked by the judge, says, no, I don't remember any conversations that she had with anybody. She never said anything to anybody at the time. And now all of a sudden, a few months later, she says, oh, yeah, she did say things to me and she said things to other jurors. That's a good part. I mean, that's like classic cross-examination. Well, is your memory better today than it was 2 years ago when this happened? So that's another argument that they make. So that is essentially what this response is. It's great stuff. It's good reading if you have the time to go through these 25 pages and these statements. I enjoyed it, but then again, I have different enjoyments than a lot of people with legal filings. Anyway, but that is the response. We will see. Again, I have to be honest with you. I think that there's going to be an evidentiary hearing. I think there's got to be, but this is certainly entertaining. I think that there's going to be an evidentiary hearing, and I think the judge probably will limit it to the questions that he is allowed to ask. It could be he'll allow the attorneys to submit questions. It could be that the Murdaugh team will try to find law that says that the attorneys could ask questions. But we will see what happens. I guess it's too early to speculate, but very entertaining. If you haven't yet, please subscribe, like the video so we can continue growing. All right, see you next time.